Good day, Doctor. My name is Ratnan Anbananthan, and for my Criminal Law 1 assignment, I will be presenting my topic, which is titled The Overlap Between Common Intention and Common Objects in Malaysian Criminal Law, a critical analysis of recent cases. The Malaysian legal system, a blend of common law principle and unique socio-historical influence, provide a compelling setting to examine the intricacies of criminal responsibility. In cases involving group offences, the concept of common intention and common object are particularly significant. These doctrines, outlined in Section 34 and 149 of the Malaysian Penal Code, respectively, establishes a framework for holding individuals accountable for their participation in collective unlawful acts. By performing this research, I understood that this research strives to provide clarity and precision in defining common intention and common objects so that it will draw upon the pertinent provisions of Malaysian Penal Code, specifically Section 34, Section 141, and also 149, while also taking into account the extensive body of judicial interpretations that have shaped these concepts over time. Without further ado, let's look into the statutes that's relevant in these studies. Starting off with Section 34 of the Penal Code. Section 34 of the Malaysian Penal Code is a crucial provision that outlines how criminal liability is assigned when multiple individuals engage in an unlawful act. The Act states that when a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. Essentially, this section establishes that if a crime is committed by a group of people sharing a common intention to commit that crime, each person in the group is held individually accountable, irrespective of their specific role in the act as a whole. Moving on, looking into Section 141 of our Penal Code, to understand the concept of criminal liability for unlawful assemblies in Malaysia, it's essential to grasp the interplay between Section 141 and 149 of the Penal Code. These two sections are intricately linked with Section 141, laying the groundwork for the application of Section 149, while Section 149 deals with the consequence of participating in an unlawful assembly. It's Section 141 that defines the very nature of such an assembly. Without a clear understanding of the Section 141, applying Section 149 becomes problematic and potentially prone to misinterpretations. The final relevant provision to our discussion today would be Section 149 of the Malaysian Penal Code, which addresses the complexities of holding individuals accountable for their involvement in unlawful assemblies. This provision introduces a form of vicarious liability wherein every member of an unlawful assembly can be held responsible for the offences committed by the other members as long as those offences were committed in pursuit of the assembly's common object or were known to be likely consequences of pursuing that object. This raises several important considerations. However, the application of Section 149 is not without safeguards. Courts have generally held that mere presence of an unlawful assembly is not sufficient for conviction. To understand the discussion much more better, a legal overview on some cases relevant to each section would be conducive and convenient to understand the whole nature of it. Starting off with Section 34, in the case of Muhammad Rizwan Gan bin Abdullah and another against public prosecutor, appellates were jointly charged with two others for under Section 160. The judge was quite unclear on whether the charge preferred against the two appellants was in furtherance of common intention under Section 34 Penal Code or jointly charged under Section 35 or other provisions of the law. The learned judge in this case mentioned that common intention is the state of mind common to all the persons accused of the offence. It is a rule of evidence and does not create substantive offence. Common intention may be prearranged or arise in the course of commission of the offence. Being a state of mind, proof of common intention depends largely on the reasonable inference to be drawn from the factual circumstances of each case. True preliminary elements are in fact necessary to fulfill the requirements of Section 34. First, there must be an evidence, direct or by inference, of the accused person present at the scene of crime. Secondly, there must be evidence to show that there are prior concert or pre-arranged plans involving the accused. And in another case of Gagatri, anak perempuan Peci against public prosecutor, and another appeal, which is on 2023, the second appellant were convicted by the High Court for the offence of murder of Ng Po Tim, an offence punishable under Section 302 of the Penal Code, and read together with Section 34 of the Penal Code. In this case, the judge affirmed the point of law from the case Faroz bin Tamure Muhammad Khan against public prosecutor back in 2016. These cases demonstrate the challenges faced by the courts in applying Section 34. Proving common intention requires a thorough examination of all evidence, including the conduct of the accused, the sequence of the events, and any other relevant factors. The courts must carefully analyze the circumstances to determine whether the accused individuals genuinely shared a common intention to commit the crime or whether their actions were independent or coincidental. This careful analysis is essential to ensure that individuals are not unfairly held liable for the actions of others based on the mere association or presence at the scene. Moving on to Section 141, the first case to discuss will be the case of public prosecutor against Tanesh, anak lelaki Krishnan and others, 2021. In this case, the learned judge Shahnaz bin Sulaiman conveyed that Section 141 of the Penal Code states that an unlawful assembly is an assembly of 5 or more persons. Hence, before an assembly is deemed to be unlawful assembly, one of the requirements is the number of persons involved must be 5 or more. In order to be termed an unlawful assembly, the assembly must be proven with 5 or more person, and also to have a common object as stated in any one of the paragraphs of A, B, C, D, or E of Section 141 of the Penal Code. Another case under the same section would be the case of Pendakwa Raya lawan Goh Sai Ak dan lain-lain. In this case, the judge stated that, however, if the common object of an assembly is to resist the execution of any law or any legal process, then it amounts to a criminal act in accordance with Section 141 of the Penal Code. The last section, but not the least, to be discussed under our study would be Section 149. The case of public prosecutor against Muhammad Azam bin Seman and another, 2024, illustrates the evidentiary challenges involved in prosecuting cases related to unlawful assemblies under Section 149 of the Malaysian Penal Code. In this case, the judge acquitted the accused due to the prosecution's failure to establish a key element of the offence, the existence of an unlawful assembly with the required number of participants. The prosecution in this case failed to clarify the roles of these two individuals played in the events leading to the victim's death, nor did they provide sufficient evidence to link them to the alleged common object. This omission was particularly significant given that one of these individuals died during the incident, raising questions about the circumstances surrounding their death and their connection to the accused. The judge in their analysis drew an adverse inference against the prosecution for their failure to produce evidence related to these two individuals. This case simply underscores the importance of meticulous evidence gathering and presentation in the cases involving unlawful assemblies. The prosecution must demonstrate a clear link between each individual's charge and alleged common object of the assembly. Failure to establish the participation of the required number of individuals or provide sufficient evidence of their involvement in the common object can create reasonable doubt to lead to an acquittal. Further elaborating on the overlap between Section 34 and 149, the same case of Muhammad Azam is very relevant. Because in this case, while the primary charge was under Section 149, common object, the possibility of common intention, Section 34, among the accused to commit the murder cannot be entirely ruled out. The accused might have shared an intention to kill the victim, which also became common object of the unlawful assembly. This case demonstrates the potential overlap between Section 34 and 149 when an offence is committed within an unlawful assembly, even if the charge is primarily framed under Section 149. It highlights the need for the court to consider both common intention and common object to determine the liability of each accused accurately. That will be it from me. Thank you very much.